My job is the best interest of the children. My only goal is to try to protect children and to make sure that they have a good relationship with both parents. I have a long history with this case, and we have gone round and round with it. And there have been some concerning issues with Mr. Duffy. I've heard multiple testimony I've heard testimony in the past where there was a physical abuse of the child, one of the children at the bowling alley. That was explained with more or less being angry by Mr. Duffy because the younger child had walked away from the older child and he was responsible for it. There was an instance where Mr. Duffy was working his job, driving late at night on an Uber or whatever it was that he was doing, and he had taken the children with him with a pistol to go help somebody recover some phone that had been left in a car. There are just a lot of concerning things that have happened in this case that they make me feel that it is important for the evidence that these older children may have can be brought in through the least harmful way to them possible. So I'm simply going to order that take place. I just need to know kind of how long we're talking about Ms. Smith, because clearly this is a case that needs to be heard with some urgency, so that if it's determined that there is no basis for those older children's statements, then this temporary restraining order needs to be vacated. If they substantiate it, then obviously we need to have a hearing to determine that.
Judge, would it be possible, since they're juvenile court records, we are not entitled to get those, would it be possible to make sure that the mother of those minor children produce the...
Well, she's not a party to this action. And she, other than coming in on a motion to quash the subpoena, I don't think I can order the mother of the older children, who is a non-party, to subpoena those records or to bring them in. You can request a judicial subpoena and see whether or not the juvenile court would honor that.
Is it? I'm not interested in necessarily having them. I wanted Ms. Smith to have access to them for purposes of questioning the minor children, because those statements were made under oath. So I don't know what purview this court would have to issue an order for her to be able to get those.
The only way of doing it would be to issue a subpoena to the juvenile court for those records to be brought to this court, and then I can put an order down today that Ms. Smith would have access to those records under seal. She would make an in-camera review of them. And again, my question is, if this order prevents Mr. Duffy from having contact with the children in this case, then there is an urgency to getting this resolved, so that if it is found to be unsubstantiated, that we can allow Mr. Duffy to resume his contact with the minor children. And
I'll make myself available. He has hired Mr. Sanders. Mr. Sanders is just getting back from vacation and unable to be here today. This is the second setting of this case. He was to be here with counsel today. Obviously, if he's hired counsel, then I don't know that a notice of appearance has been filed or anything like that.
have you been able to contact Mr. Sanders' office?
I have not today.
Have you tried and not been able to, or you just haven't tried?
I have not tried this morning. I'll be happy to reach out now.
No offense to Mr. Sartain, but believe it or not, we do have people come in and obtain delays because they say they've hired someone when they actually haven't. So I'm going to pass this case on the docket and allow Ms. Duke to contact Mr. Sanders' office to see if he confirms that he has been hired. It's unlike Mr. Sanders not to file a notice of appearance, especially if he knows that there's a motion pending. So we'll find out whether or not you have or have not hired the Mr. Sanders, and then we'll go from there.
Thank you, Judge.
Yes, sir. And I had spoke with Mr. Sanders, so I had sent out my retainer on Friday, which I have a receipt as well from Mr. Sanders' office with me presently. And I spoke with Mr. Sanders yesterday, informing that he came back from vacation and he wouldn't be in his office until this morning. And I was going to ask him to change the venue from Dixon County to Hickman County because myself, my wife, and child all live in Hickman County.
That is an issue that you can't just appear in court and say, I want to change venue. You obviously have to establish what the correct venue is.
Yeah.
But we'll find out. Let's let Ms. Duke have an opportunity to contact her lawyer, and then we'll go from there.
Yes, Your Honor.
Judge, there is a preliminary matter on this involving Miss Leslie Cole, who is the attorney for Ashley Blair. We had issued subpoenas for the minor children that had made the disclosures that are the meat and substance of the petition that we filed. So I think we've got to hear that motion before we move forward with anything else.
All right. Good morning.
Cannon County Bar. I represent Miss Ashley Blair for the,
So that we're clear, the children that are being subpoenaed are not the children of Mr. and Miss Duffy together. They are Mr. Duffy's children by a prior relationship?
Yes.
Is that correct?
If you'll remember, Your Honor, you had our minor children
you're fine.
our minor children attend visitation when those children were in Mr. Duffy's home for safety purposes. And now that they've made some disclosures, the children in this case are too young to come to court. So we ask that the older children come to testify as to disclosures they made in the other case and in this case.
All right.
So this is my motion to quash those subpoenas for the older children. The children Ella, Parker, and Jackson. Ella is 12. Jackson and Parker are twins. They're 10. The motion is on two separate grounds, a procedural ground and then a substantive ground. The procedural ground is that the subpoenas are incorrect. The subpoenas that were served, they summon the children first to Miss Duke's office rather than to court, which is the 210 East College Street. The date listed is also 5/26. We were informed by email that the date had changed to yesterday, June 15th, and my office was not informed until June 3rd that today was actually the correct date. We have not been provided with a copy of any order showing that the subpoenas were continued or that today is actually the correct date that the subpoenas were continued to. So that's the procedural ground. On the substantive ground, these children are 10 and 12 years old, testifying against their own father, who they are exercising parenting time with. Mr. Duffy is still having significant parenting time with these children. The case that was filed in Wilson County was dismissed after a probable cause hearing, and he has significant unsupervised time with the older children. It would open them up to undue psychological and emotional harm for them to testify against their own father, who they're still seeing regularly, in a case that doesn't relate to them. That's just not fair to these children when it doesn't relate to them specifically. They haven't testified in any of their own cases relating to them directly. They did not appear in either the divorce case or the Wilson County dependency and neglect. They spoke to a guardian ad litem. We would ask that these subpoenas be quashed to protect the children and on the procedural grounds. If Your Honor believes that their information is absolutely required, we would ask that the least harmful method be used here and allow the children to speak to the guardian ad litem in this case so that they are not exposed further to the court process. Thank you.
Judge, respectfully, when the case was continued on the 26th, and it was due, actually, I believe, to the mother's availability to have the children here, the order would have reflected, and it's just not been entered yet, the order would have reflected that the subpoenas remain in place. And everybody's here to testify. Your Honor, unlike the court in Wilson County, has an extended view of what has happened in this case all along. So Your Honor is well aware of the propensities of the father for erratic behavior, suicidal ideations, all of the things that the court has warned him against doing with these minor children. And Your Honor, I think, is probably much more aware than that Wilson County judge is of the dangers to these minor children. Your Honor has said it several times. This is the case where Your Honor witnessed him, and it just so happened we have had a video from the arcade at the bowling alley.
I remember the case.
Yeah. So these minor children made disclosures to their mother that were so significant, she reached out to Miss Duffy. But for the mother, Ashley Blair, we wouldn't have known any of this was going on. And now all of a sudden that something doesn't work out for her in Wilson County, she doesn't want to try to protect my client's children who are younger and cannot speak for themselves. I agree with Ms. Cole that the least harmful method for these children to testify and to bring these allegations to light is absolutely appropriate. I'm not looking to hurt minor children. I don't love the idea of them having to testify. But in this case, it's absolutely necessary. Otherwise, this man continues to hurt the minor children, telling them he's going to kill himself, carrying a gun around, continuing to drive a limo in the middle of the night with the minor children, leaving the minor children home alone by themselves. Big issues for the court.
Ms. Morris?
I represent Mr. Duffy in this action. As you know, our position is really to ask the court to dismiss this matter because most of the allegations that are before the court are based on these issues that have happened with Mr. Duffy and the older children. Meanwhile, the case in Wilson County has found no probable cause and has dismissed any action there. He's, again, as the attorney for Ms. Blair stated, he's having regular unsupervised visitation with those children. Those parties are very close to reaching a permanent parenting plan settlement in that case, as well as establishing some kind of family therapy, which we agree would be appropriate. As this court has heard before, a lot of the issues that have happened with Mr. Duffy in the past do relate to some behavioral issues with Parker and his ability to manage that. And we admit that there have been issues with Mr. Duffy being able to manage Parker, and that is the bulk of what's going on here, the bulk of the incident that stemmed to all of these allegations. And he and Mr. Duffy and Ms. Blair, who's Parker's mom, are really trying to work through those things. Again, the Wilson County Court has found no basis to suspend Mr. Duffy's parenting time of the older children. This case is really tailing on to that. And so our position is at this point, this case should be dismissed since it is entirely based on those issues in that Wilson County case. However, if the court does not dismiss it, I would also ask that the children be able to, rather than testify in court, speak through the guardian ad litem, Ms. Furlong-Smith, and that she also be able to interview everyone else in this case. As the court probably recalls, she's already done home study visits of my client's home. There's been an expert evaluation. So we were really doing very well in this case. And again, this is an issue that I think is really tangential.
Ms. Furlong-Smith, do you have anything you want to say?
I would be glad to talk with the children, the other children. I haven't. Of course, I'm not involved in the case, but I'd be glad to. I hate to just dismiss this outright until we get more.
Well, let me say this. We ain't in Wilson County, so the fact of the matter is, if in fact the Wilson County has been dismissed by juvenile court, it may be a different standard entirely than what is relevant as far as the evidence that this court will consider. But I will also say that the law is set up to try to protect young children, especially children who have been abused or have been subject to abuse, from having to come into court and testify if at all possible. That's why we have an exception to the hearsay rule that statements of children regarding abuse is an exception to the hearsay rule. So the children don't necessarily have to testify, but the statements they made could be brought in through another witness. Secondly, in criminal cases where individuals, where children are subject to sexual abuse or other abuse, the law is set up to allow them to be interviewed by the Child Advocacy Center, and a video of that interview is substituted for them having to actually go through the details of the case. So there's quite a few protections in the law intended to try to protect young children from having to come in and face having to testify. Understand, it is not particularly pleasant if anyone has ever had to testify. Sitting in the witness stand and being questioned and cross-examined is not a pleasant thing for anyone, and I fully understand that. So I'm quashing the subpoena, and I am ordering that instead that Ms. Furlong Smith is going to be allowed to speak with the children, and I am putting an order down here that Mr. Duffy and anyone else is prohibited from trying to influence these older children in any way or trying to give them a statement to make to the guardian ad litem. I want them to be unrehearsed. I want them to have a free and opportunity to speak with the children without any sort of threat of harm or having ramifications. In the interim period, obviously, I am not dismissing this action because, as I stated, I think there's a different standard for what was brought in Wilson County for what we're dealing with. And in the interim period, I don't know how long it's going to take you to do that, get that information made. What time?
And Ms. Morris has said she will get Ms. Smith a copy of that petition, just so she has it.
Whatever I
before
can
that.
obtain from the Wilson County Court,
All right.
I will file and, or provide Ms. Smith.
I'm looking at the 22nd of July as being the next time that I could. That's not a date that I had normally given out for chancery here. Ms. Morris. Ms. Smith.
Would the court want just maybe
Well, if you're going to, here's the issue. Once you find out what these children say, then you got to determine how you're going to introduce that testimony of what those statements. And guardian ad litem's report, in my opinion, could not be substituted for a live witness who would testify that the children made it. If it's traveling under an exception to the hearsay rule, you got to have a witness who's going to testify what the children said. So either Ms. Smith may have to testify in person if you're wanting to introduce it that way. And when are we thinking that you'll be able to talk with them, Ms. Smith? Okay. Let me take a recess. I'm going to check on my calendar to see the month of July. I'm supposed to be in Cheatham County, but there are a couple of days when I've got on my calendar to be back here, and I want to see if there's other. Wednesday is your day to be in juvenile court. All right. We'll take a short recess. All right, good morning. We'll start with a call of the docket.
Good morning, Your Honor.
Good morning.
That's my adoption uncontested, but I will warn you, I have a lot of support today.
We have a big courtroom.
We have a
So,
big courtroom, hopefully people will mind.
okay, well, if you're ready to take it up, I'm ready to hear it, so,
Yes, sir, I'll go get them.
all right. Okay, everybody that wants to be involved, come right up here.
We're going to have you guys stand right here.
Let us, if the adoptive parents need to stand in front of the microphone.
Okay,
That's-
we all will stand back here. How about that? Okay.
Everybody that wants to be a part of this, if you're here for this adoption, come on up. Keep coming, move.
I'm telling you, it's a lot.
It's
I think
all
we
right.
filled the parking lot, or 2 or 3. And Lisa, where's Lisa? Come on, you come over here. This is one of the caseworkers that did their home study. So I want you to testify, okay? And then we've got the girls. You can stand right here if you don't mind. Big sisters, which are important. Okay, and do you mind if,
I don't
take some
mind,
pictures?
for an adoption, anything you all want to do is fine with me. This is your courtroom.
Okay.
You just get, all these people need to come right on up here. This is a once-in-a-lifetime event for these folks, so everybody that wants to be involved in it, come right up here. So,
Okay. We still have people coming in.
Officer, that chair, give this young lady that's having a problem with standing, give her that chair and let her have a seat. So. I've had foot surgery before, so I know what it's like to have to try to maneuver when you have a bad foot. Is there anybody else that's out there that needs to come up? All right, I want everybody that's out, I'm going to put everybody under oath, and I'm going to ask you all some personal questions. Is that all right with you? Actually, those people who are going to be testifying for this adoption need to raise your right hand. Let the clerk place you under oath. All right, thank you. You may proceed.
Thank you, Your Honor. As you know, this is Judge Wolf. They actually requested you. Thank you for being here today. Option.
You're welcome.
This is Colin and Bethany James. Do you want to introduce yourself and then introduce your, okay. These are the big sisters, biggest sister. Do you want to introduce yourself and introduce your younger sister and your brother?
My name is May James. This is my sister Lucille.
Nice to meet you.
Nice to meet you too.
And this is
Judah.
Judah. And we're here for Judah's adoption.
It'll be the one time in your life that you're glad that you have to talk for your sister, so.
Public speaking is very important. You'll grow into it, I promise. Well, the James fabulous family, and we are here for the adoption of Judah. The James acquired custody of Judah from Miriam's promise, which is a licensed child placement. They accepted surrender of the birth mom and have supervised the placement. This is Lisa Mosley. She is with Adoption Assistance that actually did the home study. The two agencies shared. And so we're glad that she's here. The case representative from Marion's Promise had surgery yesterday, so she could not be here. I do have the agency's consent, my fee affidavit, and my final adoption for your review.
All right, do you want to hand that to the bailiff?
If I didn't sign that order, let me know. We all got back from vacation yesterday. So, the birth mother executed a surrender, and her surrender under oath is unknown. We're asking the court to substituted service and declare him an unknown.
Well, let me let you know, I've reviewed your file before today, so I'm aware of the
good?
facts and
Okay.
circumstances, and I will waive any requirement of any additional service since the birth father is unknown and cannot be determined. All right.
And Judah's been in the home the requisite amount of time, as you know, the law restricts 3 months. All necessary documents have been filed with Your Honor, including the home study and post-placement.
And I have reviewed the home studies.
And with that, I'm going to ask James is a few.
That's fine. If you'll step around that corner a little bit so the microphone can pick you up a little better. So,
Here we go. I'm going to ask you folks a few questions if you just want to answer appropriately to the judge. Could you please state your full names? We'll start with Mama.
Bethany Bradbury James.
Colin Phillip James.
Is everything in your petition for adoption true and correct?
Yes.
You've heard the procedural history I've given to the court. Is that true and correct? And can you confirm to the court that birth father is unknown and you're asking that he be declared an unnecessary party? Are you guys financially able to provide for Mr. Judah?
Yes.
Do you understand that after today, under the laws of Tennessee, that you'll be able to inherit from him? He'll be able to inherit from you and your daughters as if he were born to you. And I should say your family too. And do you further understand that under Tennessee law, that you'll be responsible for him as you have been and as you are with the girls, financially, emotionally, spiritually, medically, and otherwise, until he turns 18 or until he graduates with his regular high school class, whichever occurs last?
Yes.
And I'm going to cry. My son just is about to turn 18 and just graduated from high school. Oh, my gosh. That really hits you hard sometimes. Of course, those are your minimum requirements. All the judge will make you do. But I'm sure it'll extend much, much further than that. And in the adoption world, we say forever and ever, amen. And then, Lisa, could you please state your name?
Lisa Mosley.
And you are the case representative for Miriam, adoption assistant.
I did.
And do you have anything else to add to the court?
Just a wonderful. It is.
And Your Honor, I was very remiss in not introducing family and friends, and that's where we're going to leave it behind me. But those are all the formal questions I have, Your Honor. I'm going to leave it
all
up
right,
to
Mr.
you.
and Ms. James, my job is to make sure that you understand the significance of today and what you're actually assuming by going through this process. Right now, you're both the custodians of the child, and the child has been placed with you. But if I grant this adoption, he becomes your child, the same as if he was your biological child. That means that all rights and duties and responsibilities of a biological parent attach to Judah and to you too, and they will be your son the same as if you had given birth to him. You understand that? And that also means if, God forbid, something happened between the two of you and you went through a divorce proceeding, you would both have equal standing regarding custody, support, and so forth under the law. Now, you have two beautiful girls, and now you have a young boy that you're wanting me to adopt. He's cute, lovable right now. Someday he's going to be a teenage boy.
Yes, he is.
I'm not sure if you really understand that, and I'll tell you a story. I had my first son, and I was with a law partner who had two girls and a boy. And so when I had my son, I came back to work. He said, well, what'd she have? I said, he had a boy. He said, just put him in a sack, throw him in the river right now. He said, girls are the only way to go. So you've got two beautiful girls. They're going to help you with this young man as well. But you understand that this is one of those situations where he stays out and dents the car. When he's 16, you can't bring him back to me and say you've made a terrible mistake. So you both understand everything you're assuming and what you're asking me to do. Then I've reviewed your file. Everything is in order, and I will be happy to grant your adoption. So.
Thank you. Again, Your Honor, you did say the courtroom is ours, so I'm going to assume that you are okay if we stand in front of you and have a picture with you?
Sure.
Okay. Why don't we just have the five immediate family, and then we'll do our best to
Well, if
flip
we're going to do the
around.
immediate family, they can come up here. They can come on up,
Oh, that side.
come around here if
No.
y'all want to, and
Yes.
we'll do it up here.
Just the five of them, first of all, and then we're going to have the family go up with them. But I don't mind. Hey, Lisa, will you grab
I could bring a big chair here if you want to sit in a big chair. So we all
I guess it
can
really
have it.
doesn't matter, the white one's just the normal one. I promise they're in there.
Good to see you.
18 in a week. Okay. Oh, this is beautiful. Hey, Judah. Yo, make him look. I know you know how to do that. Hey. There we go. Okay, now everyone that's here, if you will flip around the best you can in front of the judge.
Individual gavel, so.
No, just stand right here in front. Don't be shy. Come on. Do the best we can. You guys, no. You're here, you're going in. Come on down.
Y'all want to stay up here? Might be better for staying.
All right. No, the little ones need to come over here. All right. Everyone needs to take one step in. Act like you like each other. One more step in. Seriously? Come on. No, you can stay there. You're cute. Okay, perfect. Burger. Huda. Okay.
No problem. I knew that, and I thought you were probably. I'll have to let them know.
I'm gonna wrap the file. Hopefully, thank you. Hopefully, I took at least one picture. Right? Responsible for the back picture. That picture.
Thank you so much.
Yep, hold on just a second. And there you go. Thank you. You're welcome. And with that, we'll just adjourn for the day on a high note. Good morning.
Morning, Your Honor.
We are overrun with children today, so
We do. We're just.
both of you raise your right hand. Let's place you under oath. My understanding is that you have, as the natural biological parents of your child, that you are asking to change your minor child's name. Is that correct?
That's correct, Your
All
Honor.
right. I know you've set this out in your petition, but I'm required by law to ask it on the record. Are you asking to change his name to avoid criminal prosecution?
No, sir.
Are you asking to change his name to avoid any sort of custody order?
Sir.
Are you asking to change his name to avoid any sort of creditors or claims that might be asserted?
No, sir.
If my understanding, you just want to add let's see, you're adding you're adding David to your child's name.
That's correct, sir.
Of course, I would expect that I would be willing to approve adding David to your child's name, so why don't we do that? So Jehu, is it Jehu?
Jehu.
Jehu David Bennett Poole will be his name here. All right? Either. Are you going to go by Jehu or David? Which one do you want to approve? Jehu? David's a good name. You might want to think about using that one sometime, so. All right, I'm happy to grant the adoption. I'm sorry, the name change. I'm still in the front. Do you have an order?
Yes, sir. I have the two petition documents underneath.
Hand this to that young man. You can have your own little gavel, you just can't use it on your sibling there. So. I'm going to ask you, both of you, Mr. Poole and Ms. Bennett, to sign your signature on this behalf. You've got your name printed, but I want you to go ahead and sign that as well, if you don't mind, please, just to signify that you were here and had this done, so. I'm going to hand you back the copies that you had, because we have them obviously in the file, and you might want to hold on to those copies that are marked file.
Yes, sir.
I've signed your order and changed your son's name.
Thank
Okay,
you.
thank you.
Thank you, Your Honor. Thank you, Your Honor.
Thank you.
Okay?
28th of,
August, this term vote is next vote.
all right.
We have, and we've agreed that if for some reason up, that we can agree to that.
Autumn has a soccer match.
Oh, that's right, yeah.
We still
Okay.
don't have her soccer schedule.
Okay. Ms. Roberts, Mr. Daniel, motion.
We said that, I'm sorry, we passed an order.
Is that what I just signed?
It's the Humphreys.
August 26th.
Yes, Your Honor, we did that.
The other attorney filed several things this morning. We're just up for discussion and see if we can work through a few issues.
All right, I'll put it on the second call.
Morning, Judge.
Good morning.
Say hello.
Thank you. Good morning.
I actually represent Ms. Nelson. I know Mr. Odell's worked on there, but Ms. Nelson is here. It looks like Mr. Nelson has also appeared.
Samantha Nelson and Jonathan Nelson.
Judge, this is our motion for default. Mr. Nelson has received criminal charges both prior to and following being served with this, and he's retained counsel for that. He has not made any efforts to contact me, or I've not heard from any attorney on his behalf.
Mr. Nelson, I want to make sure you understand that you were served with process in this case back, appears to be on April the 30th of 2026. The summons that was served upon you states essentially the following, that you have to file your answer within 30 days of the date you were served with the clerk and serve a copy upon your wife's lawyer, and that if you fail to do so, a default judgment can be entered against you, and therefore you haven't appeared in this case. In other words, as far as I'm concerned right now, according to this file, you've never even appeared, even though you're here physically. You haven't appeared in the case by filing any court of documentation. The reason that's important is you have to contest the issues that are contained within your wife's complaint for divorce. Are you intending to hire a lawyer? Well, you understand you've not filed an answer and that she's entitled to a judgment by default on the grounds, at least, it would still require a hearing as to whether or not or how the divorce is going to be put down. But the question of whether or not your wife is entitled to a divorce from you would be resolved by this default judgment. You understand that? All right, your default judgment is granted on the grounds for divorce, and we will set it for final hearing on all the remaining issues. Are there children involved?
There are children involved, Your Honor. It looks like there's a July 29th court date. I don't know if that's still available. Is there not one? Sounds great.
What that means is on July 30th, you're going to appear in front of a different judge, and that judge is going to make the rulings regarding the custody, division of assets, and so forth. You need to be prepared to either represent yourself or retain an attorney, and I understand it's not inexpensive to do that. But if you appear and you're representing yourself, that judge is going to hold you to the same standard that a lawyer would be. In other words, the rules of evidence, the rules of procedure will apply to you the same as if you had a lawyer. So my recommendation is if you're going to have to represent yourself, you might kind of brush up on what the law is regarding a divorce and custody of the child, or you can talk with your wife's attorney, and Ms. Lowe can explain to you what they're asking or what they're going to be asking for at the final hearing and see whether or not you all can agree to negotiate an agreement. So, who is the judge on the 30th? All right. I've signed the order that grants the default judgment and sets the remaining issues for the 30th of July.
Thank you, Your Honor.
Thank you. All right, I've been asked to make an announcement if there is anyone here for the case of Wilhelm versus Wilhelm. That matter is being heard in courtroom 3 downstairs. So if you're here for Wilhelm versus Wilhelm, you need to go downstairs. All right, call the next case. All right, I show that there's a motion for default judgment, but an answer has been filed. Are you Mr. Pierce?
No, I'm Mr. Butts, the plaintiff.
Oh, you are. I'm sorry.
She has filed an answer last week.
An answer and counterclaim has been filed as of June 12th on Friday of last week, so I am not going to grant the motion for default judgment since an answer has been filed. And he'll have 30 days to file, Mr. Butts will have 30 days to file the answer to the counterclaim that you filed.
Your Honor, I already filed the answers this morning before court.
All right.
I only have a amended complaint to file later today.
All right. You file your amended complaint, serve that on the attorney for the defendant in the case, and then we can go from there. So. All right, thank you.
Thank you.
Judge, this was my motion for default. In the interim, we received a notice from Ms. Gross requesting additional time, as is the court's general.
Well, the court doesn't, I mean, by law, the court doesn't favor default judgments. And, you know, courts are supposed to hear the matters on the merits rather than on default. So we'll grant Mr. Gross, how much time are you?
Ms. Gross, she
Ms.
is
Gross,
not
I'm
my
sorry.
client. 30 days is fine, and I went ahead and kept the motion on the docket today because I'm going to talk to her for a few minutes about potentially the two of them going to mediation. They're close, and my client's willing to pay for that.
Ms. Gross, I'm going to grant you 30 days to file an answer. You can either hire a lawyer to represent you and have them file your answer, or you can file an answer of your own. If you file an answer, then you have to take that complaint that was filed, and you have to go through every line of that complaint, every paragraph rather, and you either admit what is stated in that complaint, or you deny it if you don't think it's true. And then you file that answer. If you want to file a counterclaim, you can do that, but I'm not giving you advice on that, but you just need to file an answer within 30 days if you're not able to resolve this thing, okay? All right, should be granted 30 days.
Thank you, Judge, and if for some reason we set it for mediation, I'll extend that by way of an
All
agreed
right,
order.
that'll be fine. Thank you.
This courtroom hearing took a shocking turn when a judge revealed serious allegations involving a father, including claims of abuse, dangerous behavior around children, and other disturbing incidents. As attorneys battled over whether young children should testify against their own father, the tension reached a breaking point. Then the judge made a powerful ruling designed to protect the children while uncovering the truth. Just when the case couldn't get more emotional, the courtroom shifted from intense family drama to a heartwarming adoption celebration. Was the judge's decision the right one? Watch until the end and decide for yourself. Let me know what you think in the comments, and don't forget to like and subscribe to Legal Lens for more real courtroom drama.
All right, after all of the machinations and contortions that we went through in this case, it's my understanding from the review of the file and the information filed that the lady was not the child of one of the uncles or whatever it is. She's not related to the family.
So, Judge, I think if I can address that just briefly. We're here today on 3 motions filed by Mr. Vandervoort. I'm standing in for him. One of those was to address that very issue, Judge. Mr. Knowles has filed a response today in which he is challenging that.
Challenging
Number one, the DNA results that they've provided, there's no chain of custody, there's no affidavit from a doctor, there's no explanation of what this new paternity test is. Dr. Blue, who you ordered to do it, is not the doctor who conducted it. There's so many issues with it that I believe it's hearsay and not admissible. And there's a whole new issue that has arisen since our last court proceeding, is at the auction of the personal property, it was discovered the family Bible was there. And the family Bible indicates that my client's mother, along with Charlie Mike, were married 4 months prior to her birth, along with other typewritten documents that evidence the same.
All right, so you represent the lady out in Washington State.
Yes, Judge.
And you're saying that these new developments basically may go counter to any sort of absolute determination of this DNA testing that wasn't done according to the court order.
Yes, Your Honor, if the court
Or was it
determines
done according to
it's
the
clear
court
and
order?
convincing evidence that they were married prior to her birth based on these families.
All right, so do we need to have a hearing or we just do an argument?
We are, Your Honor. Yeah, the scenario being what I've Bible and the notation that I found. Again, we're going back and doing our case. If you were married at the time of birth, the husband, biology had nothing to
Do we have a certificate of marriage from whatever state
Well,
they?
we have a birth certificate with
The father.
name on it. But again, I'm a bystander. But again, it's a situation where we're gonna have that hearing. Necessarily, the law at the time, biology and DNA had not developed as it was, so again, we have whether or not the law or biology if they can prove that they were married. The birth
Well, we
certificate-
prepared to do that hearing today.
Judge, if I could address that, I think based on the response that Mr. Knowles has filed, Mr. Vandervoort's going to need some time to take a look at that, to come back and address some of these issues. So what we're going to ask is that these, and the other two motions are also related to this. So we're going to ask that all three motions be reset to the court's September date.
All right, you have a date in September you want to have it heard?
I don't.
Well, I gave 6 days in September to, that's a Friday. That's a good.
I don't have Mr. Vandervoort's calendar, but I'll speak for him. And if we need to.
Anytime that I see Miss Roberts smiling the way she's smiling about a case, I dread what's going to happen when we
Right,
actually
Judge.
get into the case.
Love to make new law.
September 4th is a good day for me, Your Honor.
All right, so that we're clear, these motions, the three motions that were filed, which are the motion to confirm and the determination of the DNA testing, and the motion for attorney's fees in this case and the next case, filed by Mr. Vandervoort, are all going to be reset for the September 4th date. And on that date, we're going to have a hearing with evidence presented to the court for me to determine whether or not this lady is or is not the heir of or a legitimate heir. And that will be any evidence regarding a family Bible that's been discovered, if I understand correctly.
Which is lodged with the court.
The family Bible is lodged with the court? Okay. I wasn't sure if it was just a photocopy of the page or it's the actual Bible. I may need it to decide this case more than just the notations on it, so.
Your Honor may have stated this, but that hearing will also include my motion to dismiss their claim, attempting to disestablish Ms. Rundle. The current law is they don't have standing to challenge Ms. Rundle as an heir.
All right.
So I think that's the first hurdle. My motion. Their heirs.
Well, we've got 4 good lawyers standing in front of me. I want you to draw an order that reflects what we're doing on the September 4th date in clear and concise language so that when in 3-4 months, when I pick up the file, 3 months, I guess it is, when I pick up the file to refresh my memory and look at it again, I want to make sure I know what we're doing. So.
A ruling on whether or not the parties are all related to it, and then whether or not.
I would expect that this is going to take the majority of the day, so I would not want to set another lengthy. I'm not giving you another day. You are not the only court I have to deal with, so.
Judge, Mr. Vandervoort left me a very simple and straightforward matter to handle today, and I have failed, so.
Except that Mr. Vandervoort scheduled it like that. We'll take judicial notice.
Well, you know, if you remember Ship Wings, he came in front of Judge Birch back in Chambers one day years ago at the old courthouse, and Judge Birch had some loud, garish outfit on, and so Ship just made fun of him left and right, as he was wont to do. And Judge Birch finally said, "Mr. Williams, what do you have today?" He says, "You can't touch me, Judge. I got an uncontested divorce." So Judge Birch took that file and went through it and found some technicality and dismissed the action because of the fact that he hadn't done it correctly. So don't tempt fate.
That's right, right. Correct. Thank you, Your Honor.
All right, September 4th.
Which one was that? Jack Johnson.
This was an exception filed to a claim, and I don't know if there's anyone here on behalf of the claimant.
Anyone here to represent the interest of First National Bank of Omaha? No one here to prosecute their claim, then your exception is granted.
Thank you, Judge.
If you'll have Mr. Vandervoort submit an order, please. This is here for a motion to adopt a temporary parenting plan.
It is, Your Honor. It's my understanding from Mr. Sartain that
While we're waiting on the files, my understanding is we have only two things, we have three defendants, but only two motions. There's a joint motion to suppress that's been filed in State of Tennessee versus James Thomas Dubois Jr. and Billy Ray Perry. They have filed an amended joint motion to suppress, and that is for hearing. And then there's a motion to revoke bond in the McCoy case. Is that correct? And you represent Ms. McCoy, Mr. Brown? Oh, who does? Oh, you do? So why are you here? Okay. So you are here for the hearing on the motion to suppress. All right. Eric Zuler's with the Drug Task Force.
They are. May we have a moment to confer with our clients? I think we may just ask to continue the motion to suppress.
All right. You need to talk to him. What about Ms. McCoy? Is she in custody or is she is?
She is. She is, Your Honor.
Talk to your clients. I'll step off. We'll let you talk to your folks. Mr. Massengill and Mr. Spratt have asked for an opportunity to speak with their client about whether to go forward with today's motion to suppress. We can go forward on the McCoy case regardless of whether or not we do the other, right? Okay. All right. You have another copy? All right, I'm going to step off, let them have an opportunity to talk. Please let me know as soon as they are ready to proceed. So.
Back in session.
All right. Are we going to proceed first on the McCoy case?
Your Honor, if we're going to ask for continuance on the suppression of the Dubois and Perry case, we'll take that up and get them out.
Yeah,
of
we'll
here.
take that up first then. I did not bring my calendar in. You got yours? I didn't bring my calendar in. Do you have yours? So on the people in the waiting room, are they for the McCoy case or this case? Do we know? Did you say you had some people that were in the waiting room?
I do, Your Honor. I think there's three, actually.
We have 3 people in the waiting room. They're all for this case? Or
No, sir. They're for the
McCoy?
McCoy case, yes, sir.
All right.
Your Honor, we, as the court's noted, we filed an amended motion to suppress. That was to allege standing in the pleading. There's some video that the state is still going through, and there could be a need for a second motion based on a different theory of the search. So, which, rather than necessitate a second motion, we'd rather just work through all that. We could file a second amended motion to suppress, depending on what we find out. So I think it would probably be better to not have 2 motion hearings.
All right, so you're requesting to continue this. Do we know how long? State have any opposition to that? Do we know how long it will take you to conclude the new discovery and be able to go forward on your motion, either this one or the second amended one?
If I may explain, there is a parallel case that was worked about the same time as this one that was not charged, but may have relevant information. I have received that entire case file this week while I was out of town. I was able to access it for the first time this morning. There are numerous videos in it, and the defense has been asking for certain videos. I don't know if these are relevant or not until I watch them. And I don't even have a good grasp on how much information is in that. I am in the middle of Judge Lockhart Mash's trial term and expect 2 or 3 different cases to potentially go to trial this month. We can set it in the May term. I know your May term is very full. But that would be the earliest that I could be ready is May.
Is there
I'll set.
Well, my thought would be, let's put it on the first of our criminal docket. Did you have a particular reason you had to be here on the 20th, General, as opposed to the 13th?
I was looking to see when the new prosecutors academy was going to be. And I know it is that week. I'm seeing.
This is what you were teaching at? Is that right?
Yes, Judge, they're not sending me back remedially.
I didn't know if.
Judge, I'll be teaching the morning of the 14th, so I will be here the 13th for that docket. If it goes terribly late, I may have to go.
My only thought would be if we just set this on the 13th and then find a day in the term, hopefully we'll know which cases are going to trial. And if a day opens up, we can set it for that term or the next month, which would be June. June is when we were in Stewart, Houston. I have some dates in July, but let's put it on that 13th to figure out if there has been a second motion filed. Will that give you sufficient time to go through the videos, you think?
I think so, Judge.
Then we'll put it on the 13th of May for us to determine when to set the actual motion. That will be your deadline for filing this motion, and then we'll set a date for it on that time.
Thank you, Judge.
All right.
That's your grand jury testimony. Thank you, Nathan.
We're ready on the McCoy case now.
We are, Your Honor.
We'll bring out Miss Natasha McCoy. All right, this is a motion to revoke bond that the state has filed. You may. All right, we have had a request to cease the live stream based on some issues that are going to arise in this case, so we're going to go ahead and terminate the live stream, kind of like all dressed up and nowhere to go.
A bombshell courtroom twist left everyone stunned when a DNA test that supposedly settled a heated inheritance battle was suddenly challenged in court. Just when it seemed the case was finally over, attorneys revealed a shocking new development: a decades-old family Bible containing records that could completely change the family's history. The DNA results pointed in one direction, but the newly discovered evidence appeared to tell a very different story, throwing the entire case into chaos. As tensions rose, lawyers fiercely debated whether the DNA evidence could even be trusted, raising questions about how the test was conducted and whether proper procedures were followed. With a potential heir's future, family legacy, and inheritance rights hanging in the balance, the judge made it clear that the truth had not yet been decided. Now, both sides are preparing for a major courtroom showdown where DNA evidence, family records, and long-buried secrets will all be put to the test. Is the DNA test wrong, or has a hidden family secret finally been uncovered after all these years? Let me know what you think in the comments, and don't forget to like and subscribe the Legal Lens for more real courtroom drama.